if you ever lose the ability to do that yourself. And that can be things like financial decision making, healthcare decision making, and also just how do you help have someone come in and help take care of you, right? So again, welcome everybody. I'm attorney Justin Randall here with Hooper Law Office. Our topic today is planning in advance of needing care. So the different types of things that somebody's going to want to think about when they are concerned about what happens once they need that level of care, or if they ever need that level of care. And so what I mean by long-term care is not necessarily like a long stay in a hospital, anything like that. It's the something I'm sure many of you are familiar with, the planning for nursing home expenses, assisted living expenses, or maybe even at-home care, depending on the situation. How do you plan for it? What types of documents do you need to have in place, or should you have in place at the very least? And how do you financially plan for that too? Because it is a big expense. Long-term care is not cheap. And there's a huge misunderstanding, I think, in the general public of exactly how it's paid for, or how much it can cost, or whether somebody may ever actually need it. And so regardless of whether someone expects to need this level of care, it's something you should plan for, because it's something that's unfortunately out of a lot of our control, whether we ever need that level of care. So first and foremost, there are certain documents that everybody should have, regardless of whether they are planning for long-term care or not, but they're really essential when it comes to actually having people have the right authorities to help you if you do need that level of care. So first and foremost are powers of attorney, right? So both for finance and health. They're two separate documents, but you should absolutely have both. A HIPAA authorization to have, so the people you need to have access to that healthcare information can actually talk to the doctor on your behalf, and a living will, whether or not you want to be kept on life support. So the reason the power of attorney for healthcare and finance are so important is if you don't have one in place and you lose the ability to make your own decisions because of cognitive decline or some other sort of incapacity, without that document in place, your options are very limited in how somebody could step in and help make decisions for you, right? If you don't have a power of attorney for finance in particular, somebody doesn't have access to your bank account. Somebody doesn't have the ability to pay those bills for you that may be ongoing, can't file taxes for you. It can't be anything like that. So without that in place, sometimes the only option for somebody who doesn't have the capacity, the legal capacity to sign a new document, is to go through a process called guardianship. And for the most part, if somebody has a well-drafted financial power of attorney, they don't likely need to go through that guardianship, because the person they've nominated in that role already has the authorities they need to manage those things. Guardianship is really a sort of an option, of last resort that you only want to go through if somebody doesn't have that properly drafted power of attorney, or maybe is, even if they have that power of attorney, is in some ways causing financial harm to themselves. Because an important thing to remember is that financial powers of attorney don't actually take authority away from the person who's granting those authorities. They're sort of sharing them. So if somebody is causing harm to themselves financially, then sometimes the only way to stop that from happening is to go through guardianship. But for the most part, if you need somebody to step in for you, you don't have to have a guardianship. You just need to get that power of attorney in place and nominate your chosen individual or individuals that you want to act for you. Oh, and before I forget, just so you're all aware, at the end of this, you will receive a couple of items from us. So one is our long-term care planning pyramid. It's just kind of a good way to visualize sort of the orders of priority, and sort of the bottom of the pyramid being the base, and going up and up, the priorities are maybe not as important as the lower ones, but you need those foundations for your care to be planned for in advance. That's one of the things you'll receive from us. Another is our feedback form, which is where you can write down any feedback you have, or maybe say, hey, there's a topic I'm really interested in, is this something you guys would ever talk about? But it's also a place that if anything we talk about today makes you want to come in and talk to one of us here at our office, you can put on that form that you would like us to reach out to you to set up an initial consultation. They are complimentary. They don't cost anybody anything to come in and talk to us. They are usually scheduled for around 2 hours. And that is where we can really address any problems or concerns that someone might have, especially in relation to long-term care or estate planning. So if anything we talk about today makes you think we really need to come and talk to somebody about this issue for our family, please feel free to fill that out. So moving on from financial powers of attorney, healthcare powers of attorney are essential as well, just so that somebody can help make the right healthcare decisions for you. So the big thing that we often see in maybe somebody who has a power of attorney for healthcare, but not one that is properly drafted for their needs, is, well, maybe the person can't admit somebody to a long-term care facility because that's not what, the person says, well, I'm never going to go into that facility. Well, I mean, in theory that I understand that, but it is really important for a healthcare power of attorney to allow somebody to admit you or a loved one to a skilled nursing facility, a hospital, a assisted living facility, because it might be the care that somebody needs. And if that person doesn't have the authority through the healthcare power of attorney to do that, then that's again where you might be in a position where you're going back to guardianship court, because it becomes a matter of what do I do to help that person, not, what does this document tell me I can and can't do? And if the document says you can't do something, that's when guardianship court is the only alternative if the person doesn't have the ability to sign a new document. And HIPAA authorization is pretty straightforward why anybody would need this, but you've all signed them, I'm sure, every time you go to the doctor's office. HIPAA, just for those of you who aren't familiar with that term, is the law that says doctors can't give out private health information without prior authorization. So this is the yes, you can talk to these people list, essentially. And living will is important, just to have something there that codifies your wishes about what you want to happen if you are not going to be able to recover from life support. So if you're on a ventilator or you're, is there a feeding tube involved? Any of those sorts of treatment options. If you're not going to get better, do you want to be kept that way indefinitely, or do you want to be removed? And that's a personal choice, obviously, on that, but you want to make sure it's clear so that anybody who has to make that decision is not sort of left, open-ended. They know what your wishes are, and it also protects that person when following those wishes, because it's clear that that was your wish to begin with. So those are really sort of foundational documents that you need in order to have anybody step in for you, right? And make the right decisions. And the reason it's so important, especially on the financial side of things, to have a well-drafted financial power of attorney is without the right authorities in that document, your power of attorney may not be able to actually step in and do the proper planning that you would need them to do in order to protect assets from long-term care expenses, and for you to have the level of control that you would want over those assets. So it's, the problem, for example, just to give you an idea or more of a concrete example, is when you see the state statutory form that you can, you see a lot of these where it's initial next to the powers you want the person to have, but it'll say things like, oh, that person can or has banking powers, or they have business powers, but there's no description of what those mean in any way. They're just those words. And the problem with that is it's really unclear what that even means in that definition. And it might be interpreted differently depending on who is reading it. But in particular, when it comes to the types of authorities we would need someone to have for long-term care and to plan around long-term care, those documents are just not adequate. They don't have the authorities we would need. And so when you're looking at a financial power of attorney, the more specific it can be and the more descriptive it can be in those powers, the better it is for you. Even if, I use this as an example a lot, but there's sometimes authorities in there that, most likely you're never going to need, but you never know. A really common one I always sort of jokingly point out to people is, there's usually some sort of power in there about like oil and mineral interests, dealing with those. You may never have that interest, but it's important to have the power for someone to deal with that specifically. And that applies also to long-term care authorities, like things like applying for benefits or dealing with taxes or filing tax returns or setting up certain types of trusts, things like that. So the reason people like to look at planning around long-term care in particular is just because of, primarily the cost, right? It's expensive. And this is where you often hear people sort of refer to it as, I don't want the nursing home to get everything or to take everything, which is a bit of a like, I guess, misinterpretation of what actually happens. It's not the nursing home taking everything. You're paying for care, and care is expensive. And they earn what they're paid, but it is expensive. So people tend to not have enough income to cover it, especially in retirement. This is where people then dip into their assets and start paying down. And this is where you hear about, well, my mom or my dad, they spent through everything they had because they were in care for X number of years or months, and it was really expensive. So the reason people want to plan around it is they don't want to necessarily spend down through everything. And there can be a number of really important reasons why somebody wouldn't want to spend down through everything they have. Some people, for example, want to leave a legacy asset of some kind. Maybe it's a family cottage or a farm, and it's really important to keep that in the family. And they know that if they need care, if it's their primary asset, they may not be able to pass that on to the same extent that they would have otherwise, or maybe there will be some added expense for the family, or maybe the family has to, pay off a Medicaid lien, for example. And planning in advance can help you protect those assets. So to give you an idea of what the cost of care generally is, and this varies obviously depending on someone's care needs, but this is sort of the standard that you would see in this area being, Fox Valley area in Wisconsin. But you're looking at for assisted living facilities somewhere in the neighborhood of maybe $5,000 on the low end to $8,000 on the upper end per month, so $8,000 on the upper end. And that's if somebody especially needs memory care of any kind. Memory care, if you have Alzheimer's or dementia diagnosis, you might need a higher level of care, right? Skilled nursing is usually the most expensive. So that's when somebody really needs sort of round the clock care. Their care needs are above and beyond what an assisted living could ever provide. And that is in the neighborhood of maybe $9,000 to $11,000 a month. So you can see how people spending that much per month, they generally don't have that level of income in retirement. It's easy to see how somebody might spend through their assets in a relatively short period of time compared to how long it took them to build those assets. At-home care can be the cheapest. Depending on the level of care somebody needs or the hours per week they might need, you're looking at, maybe about $25 an hour, I think is kind of the standard, maybe 27 now. And you could do the math and figure out how that could either be the cheapest level if you only need a couple hours a week, or if you need round the clock care, it actually is more expensive than a skilled nursing facility. So if you need skilled nursing, at-home care is going to be the most expensive option. So that's not the right tool for everybody, is what that means. As much as it is ideal for someone to stay at home if they can, it's sometimes just not a feasible option financially or health-wise. So it's expensive. And when people hear about those expenses or kind of understand what that looks like for them and what maybe the size of their estate is, they start to become concerned about, how do we pay for this? I don't want that to happen to me. And, you'll always get somebody who maybe says, I'll never go to a facility. And I can appreciate that sentiment, but it is not something that we generally have a lot of control over, especially as we age. And somebody just may need that level of care. And a lot of people do need some level of it at some point. So, getting beyond the we'll never need it, if you do want to plan around it, you start to wonder, how do we cover this expense? How do we protect things? How do we, receive the level of care that we want to receive for as long as we possibly can? Because spending down doesn't always provide that for a very long period of time if you're just paying the rate. So looking at that, there's a couple of different things that you need to consider when it comes to what ways that you can possibly pay for care. So the first thing I always tell people to look at is, if you haven't taken a look at it or gotten a quote on it, look at long-term care insurance. So this is not like long-term disability insurance, which it often, I have people confuse the two. Long-term care insurance is specifically a type of insurance that will pay for a stay at an assisted living facility, at home care for a certain amount, skilled nursing facility, all of the above, right? And it usually pays a daily amount maximum. So you'll see anywhere from like $150 a day to $300 a day, or, whatever the going rate is at that point, depending on the policy that they've purchased. And then it'll usually have a maximum lifetime payout. So it'll only pay so much or for so long. And the reason this is really important is a lot of facilities require that somebody show they can privately pay for 1 to 2 years before they will let them live there on Medicaid or some form of means-based assistance. And the reason for that is Medicaid pays generally a lower rate to the facility than somebody privately would be, and they need to cover their expenses. So a long-term care insurance policy is a really good tool to use if it's something you can afford to purchase, because it allows you to pay for those 1 to 2 to potentially 3 to 4 years, depending on the how good the policy is and how expansive it is. And that provides you choice. It provides you the ability to say, this is not the facility I want to stay in. I want the facility with these amenities, or with this location near my family, or, with these types of care options. I mean, it provides you that choice where somebody who can't privately pay that period of time, it's not that they're always stuck in, I think there's a big misconception that Medicaid facilities are not where somebody wants to be. But that's not necessarily true. A lot of them are very nice, but it's just a matter of there are fewer of them, and you don't have the choice or the flexibility of that choice to say, I prefer to be in this location near my family versus this one facility in the county. So it just provides you choice with those long-term care insurance options. And it's generally an ideal time to look at it if you're mid to later 50s, early 60s, retirement, kind of early retirement age, something like that, mostly because of affordability. I mean, the longer you wait, the more expensive it gets, because they know you're closer to potentially needing that care, and also your health can play a factor in the cost. And unlike health insurance, they can just say, we won't cover you based off of a certain health condition. Like if somebody was diagnosed already with Alzheimer's or dementia, they'll probably just say they won't cover them. So that is the number one way I recommend people look at paying for care, or to have that sort of funding of that care option, because it is the way that you can maintain the most control over all of your assets, as well as have some financial protection over that potential liability of your care. It's also not something that everybody is going to be able to do, though. So, I mean, some people, it's just too expensive for them, and you cannot eat your long-term care insurance policy. So it's important to still be able to live the life that you want to live, but it is always worth looking into if you haven't done so already. Don't listen to your neighbor who said it was too expensive for them, or read it's too expensive online, or whatever it might be. I mean, the only way you can know that for certain is if you get a quote of what it would cost you. So long-term care insurance is, the first and foremost what I would recommend somebody look at if they haven't already. But if you have, and you say it wasn't for me, or it was too expensive, or they just wouldn't cover me because of health conditions, well, then you're looking at some other alternatives. The other ways that people tend to pay for care after they, have spent through their assets themselves is looking at something like Medicaid, or if you are a wartime veteran, there's a VA aid and attendance improved pension program that can help pay for care as well. These programs, though, have asset limitations on what you can have and still qualify. And, they have income limitations as well. So when you're looking at Medicaid, for example, how much you are allowed to have and still receive that benefit depends on whether you are married or single. If you're single, it's pretty straightforward. It's, $2,000 in assets. The home is not countable, but they could place a lien on it if they go through with doing so. You can have a life insurance policy of not more than $1,500 in face value total. So you could have like $3,500 face value policies in theory. If it is over that amount, then they look at the cash value of the policy. So term insurance is not a countable asset then. They will look at as a single person, they'll look at all of the other assets, your retirement accounts, your bank accounts, any sort of other real estate that you might have. And they will look at what the cost of that is and say, you have to spend through it down to $2,000 before we'll even cover you. So once that single person is on Medicaid, they can, all of their income except for $45 a month has to go towards the facility to help cover Medicaid's expenses. So this is where you're looking at, $45 a month for what they call the personal needs allowance. And it's these days that barely covers anything, right? I mean, you could barely go out to eat or get a haircut for $45. So it's not a lot, and it doesn't provide that person with a lot of choice over the types of care they're getting or supplementing that care with things that maybe Medicaid doesn't cover. If you are married and only one spouse is receiving care and the other spouse is living at home still, what they call a community spouse, that spouse at home gets to keep certain assets. So the home is not countable at all for that community spouse. The healthy spouses, IRAs, 401ks, any of those types of qualified retirement accounts, 403bs, any of those, if it is the healthy spouses in their name, that is not available for their spouse's care. So that is actually protected in Wisconsin from their spouse's care. All of the healthy spouses' income is they can keep. There's no limit on how much they can receive. They're allowed to keep all of their income. That life insurance still applies. I forgot to mention this for a single person, but this is the same as well. They can keep a vehicle of any value as long as it's just one vehicle. And then they pool together all of the available assets for the spouses and say, anything I didn't just mention that's exempt, they look at the total value and they say, let's divide that value in half. So I'll give you a hard example here so you can help kind of conceptualize this. But let's say somebody has $200,000 and what Medicaid would say is available for the spouse's care. Dividing that in half is exactly $100,000. And Medicaid says you can keep anywhere between $50,000, no less than $50,000. They can't force someone to spend lower than that. But you also can't keep more than about $130,000 in available assets. So in my example, that half of the $200,000 falls within that range. So if you fall within that range, you keep whatever your half is. If your half was below that $50,000, they can't force you to spend below that amount. But let's say somebody had $300,000 in available assets, they don't get to keep $150 because that's above the maximum allowed that they're in order to qualify for Medicaid. So there's oftentimes for middle-class families a lot of spending down that occurs, and this is this happens for a lot of families. It's not just necessarily on any spectrum of the like lower income, higher income. A lot of families are going to have to spend down if they ever want to receive Medicaid assistance. And some people can privately fund. I mean, if they are receiving enough in retirement income, they don't ever have to worry about Medicaid if they're able to self-fund the whole way through. But that's not the majority of the population. So there's a lot of things that people want to protect. They might say, I don't want to spend down to that amount because there might be a lot less for the healthy spouse's care should they ever need it later. The VA improved pension benefit is very similar to Medicaid's rules, although they don't differentiate between a healthy spouse and or a married person and a single person for the VA. They just say, no matter what, you can keep the home of any value. It's not an available asset. Up to 2 acres surrounding the home, unless local zoning laws require that a lot only be 10 acres or something like that. Then you can keep it based off of your local laws. And $130,000 of other available assets. So they don't do the dividing in half or certain other things are exempt. They're a lot more. This is the amount you get to have in order to qualify. So that's the asset limitations for the VA. The other sort of side to the VA is also service connected. So this benefit is available for wartime veterans or the surviving spouses of wartime veterans. And in order to be qualified as a wartime veteran service-wise, you have to have served during what the VA considers a wartime period. And those dates are a little different than what you might think of in terms of like historical wartime dates. Like World War II, according to the VA, ended in 1946 is when that wartime period ended. So it's a little different than what you might expect. So don't count yourself out necessarily. So the wartime period service, you had to have served for at least 90 days of active duty. Only one of those days had to have been during the wartime period. So you could have started right at the end of that wartime period, your first day, and was the last day of the wartime period, and still qualify as long as you served active duty for 90 days. You don't have to have been like actually in the theater of combat. You could have been, here still in the US and served during that period of time. I've had people, they were stationed in Montana during, the Vietnam War, for example, right? But you also could not have been in the reserves. It does have to be active duty, and you couldn't have been in training for those 90 days. It has to have been actual service after training, and no dishonorable discharge. So there's a lot of service-connected things with this, and it's not available for all veterans. I've seen lately a lot that were more in the Cuban Missile Crisis era, where they just, unfortunately, that was not considered a wartime date, so they don't qualify for this. But the way this benefit works is once you asset-wise are qualified and you are service-wise qualified, you can receive a direct pension to the veteran's bank account or the surviving spouse's bank account that can help supplement care costs. So for a wartime veteran themselves, if they're a single veteran, it's about $1,800 a month. If it's a surviving spouse of a wartime veteran, it's about $1,200 a month directly to that person. So it's not going to cover skilled nursing by any means, but it can help supplement that care. So if the question becomes, well, then, I have more than that. I have more in assets than I could ever hope to qualify for this type of benefit, or I would have to spend down a lot to get there. How do we protect this asset? Or how do we protect ourselves and maintain that level of control over our quality of care? So you hear a lot of people talk about, well, I'll put the home in the kid's name. And I say the home, but it could be any asset. This is just a really good example of this. But the reason that can be, or actually there's a couple of reasons that can be a really bad idea. One, you may have heard of this 5-year look back or for Medicaid. People talk about it a lot, and it's not 7 years. It's not even talked about going up to 7 years. We hear that a lot. I don't know where it's coming from, but it's 5 years for the look back for Medicaid. For the VA, it's a 3-year look back period. And what that look back period means is if you gift something away for less than fair market value, so you didn't sell it for the fair market value, meaning you either gifted it or sold it kind of on a really good deal to a family member, or just gave them a substantial sum of money, right? That if that happened in the 5 years preceding your application for Medicaid assistance, then it is a penalty for you. You get a penalty period. So that is based off of how much you gave away over the last 5 years for Medicaid, and 3 years for the VA. So it is oftentimes that people make these gifts to protect it. They try to get it out of their name, but they may not be aware that they're creating a problem when they do so. So the divestment part of it, you want to do knowingly if you're doing it and understand the full consequences of it, and not just sort of do it thinking you're protected automatically. Say you fully go in knowing that that's a possibility. The other reasons that gifting these assets away and putting it directly in your kid's name can be very dangerous is you may protect it from your care. You might have gotten it out of your name for Medicaid. Maybe it's 10 years later and you never needed care, but you got it out of your name and you think you're all set. But the problem can be when you put something in someone else's name, their liabilities also become the liabilities of that property. So you might have protected your home from your own care, but then opened it up to, the lawsuits of your kids or them passing away and they own that property. Does it go by the terms of their will? Or if they were, filing for bankruptcy, that's not their primary residence. So they might not get those same protections that you would get if you filed for bankruptcy. So it really opens up your assets to someone else's potential problems. And that's just not what you want. The whole point of doing that would have been to protect it from your care, not to open it up to everyone else's liabilities. So that is one of the number one reasons that it's really risky to put an asset directly into the kid's name with the intention of protecting it from care. With the home, another huge problem is when it comes down to tax planning. So when you gift an asset like your real estate, or in theory stocks, anything with a capital gains associated with it, when you transfer that to them rather than sell it to them, you transfer your cost basis in the property over to them. And what that means is when they sell the property, if they are not the residents of that home, they don't get an exclusion from capital gains like you do when you sell your home. So they may have to pay, some portion of the gain from what you bought the home for versus what they sold it for, directly to the IRS. And that may not be what you intended for them to receive in terms of an inheritance. You might have wanted them to get the whole value. When you pass an asset like that through your estate, you leave it to them after you pass away, then it gets adjusted to fair market value so that it looks like to the IRS that there are no capital gains associated with it, assuming they sell it in a relatively close period of time to when you passed away. And if they hold on to it for another 20 years, there's probably more capital gains to pay, right? So tax-wise, it's just not a really good idea. The other problem can be when you look at, that sort of real estate going over to the kids, is it's a huge loss of control. And this is generally not as much a concern if somebody is already thinking about putting it in the kid's name, but it can be where somebody says, you hear these horror stories of son tried to evict mom because he's now the owner of the property and she wasn't paying rent like she was supposed to, even though it was her property to begin with. The son in this scenario has a legal right to evict a tenant, right? And that is not generally something that you would want to have done if you were gifting property over to somebody with the intent of living there and protecting it. So, hopefully your kids would never do that to you, but it highlights the huge loss of control. Another problem that comes up, which is a little more minor in this, is when somebody says something like, how do I, what if I continue to pay the property taxes and all of that? Well, the Medicaid, that looks like you were paying someone else's property taxes, which looks like a gift. So a better way to plan around protecting an asset like this is to look at a different way to hold it rather than directly in the kid's name. And often what we're looking at for things like this is some form of an irrevocable trust where the kids may be the trustees, but the benefit of doing this is that trust is not available to their personal liabilities because they don't own the property yet. They're just managing it as trustees. Usually you're granted some form of occupancy right, where it says they cannot evict you or charge you rent as long as you continue to pay the property taxes and utility bills. And then it's not a gift for Medicaid because you're receiving something in exchange. It's fair market value equivalent. The other benefit is when you pass something to somebody through this type of irrevocable trust, you can still get that step up in basis so that you wipe out the capital gains. So it's really the best of all worlds with this, and it protects you from all the things that can still go wrong. So there's a lot of things that we might put into this type of plan if it was something that somebody really wanted to protect. So it looks like I'm running a little over on time here, so I won't keep you guys too long, but our topic next week is actually what happens if you were unable to plan in advance? What happens if somebody already needs care? And you don't maybe have the 5 years for Medicaid or the 3 years for the VA. What do you do in those circumstances? And so we'll talk a little bit about what somebody can still do to protect their assets in the event they don't have that amount of time available to plan ahead. And the good news is that there's still things somebody can do if they are already receiving care to protect some of their assets. Please feel free to join us next week, and we actually are having our first in-person seminar again coming up, I believe in next month in August. And if you go to our website, hooperlawoffice.com, there's a sign up for that if you would like to attend our wills versus trust seminar in person. So please feel free to sign up for that. It is August 18th. So it will be here in Appleton at the Bordini Center, so really close to our office. Just one quick reminder before I let you guys go today, please, when you see that feedback form, if you would, fill out with any feedback, or if you do want to come talk to one of us, fill out that you would like us to reach out to you to set up an initial consultation. Again, thank you for joining me today, and I hope you guys have a good day.